Hi everyone, my name is Elvis Abenga from BEGI'S Law Offices and Chambers. Today I'm here to teach you how to draft some legal documents for purposes of moving the children's court. So maybe you're a lady and you want child support and you want maybe to get custody of your child, or you're a guy and you want you've been denied access to your child and you want to get visitation rights or some kind of access communication. The documents that are drafted are similar. So for purposes of this video, I will act as a lay person who's drafting documents for themselves. I'm a guy, but I will use the name and style of a lady called Jane. So I'll assume for purposes of this video that I'm Jane and I want child support and I want child custody. I'm not using a lady's name to say that it's only ladies who move the court, but just to make it easier, because the majority of people who come to the children's court are ladies. So here is a blank document and we are going to start. I will center align it, caps lock, bold. So I start by recognizing our country, Republic of Kenya. Then I talk about the court, in the children's court at Nairobi. And now in Nairobi we have two children's courts. One is in Milimani, another one in Makadara. So I specify that the one I want is the Milimani one. That's where I'm filing. Then I write the case number, children's case number dash, but as at the time when I'm filing this document, I don't yet have a children's case number until it's filed. That's when the court gives you allocates a number, and then you can put it up later on. Dash of 2022. Now, before I even move further, I need to explain some concept here. For children matters, most children matters usually start on an urgent basis, because if it's matters of children are very all urgent. Either a child is sick and needs medication, a child has been kicked out of school and needs to go back to school, that kind of stuff. So because of this, we usually file an application inside the main suit. And this will become clearer with time as you go through this document. So we'll file an application under what we call a certificate of urgency. So what we're telling the court is, we know the court is busy, we know you have other things, but we need the court to urgently look at this application so that we can get some kind of interim orders or interim reliefs that can help us survive at least until when the matter is heard. I'll explain that in using another illustration. Children cases, main suit hearings take a while to come, sometimes 3 months, sometimes 4 months, or sometimes up to 6 months to be heard and determined. You literally cannot sit down and wait for the entire matter to be heard to conclusion for a child to go to school. It will be detrimental. So the law has provided for a way to urgently move the court to get some kind of interim relief, even as you wait to go to court and to have your matter heard and determined. So here we've done the first citation. It's Republic of Kenya in the children's court at Nairobi, Milimani, children's case number, ... Then we have to acknowledge the name or names of the child. Today I'll come up with a fictitious name. So I'll remove underline. I say in the matter of Darren. Darren is just a random name I've picked from I don't know where for purposes of this video. Darren Doe. Then I put into bracket a minor. So the word minor is used in court to refer to a child, someone who has not yet reached the age of majority. According to we have a law called the Age of Majority Act, that prescribes the age of majority to be over 18. So anyone who's under 18 legally is considered to be a minor. So we've acknowledged the name of the child there. Then we move on. So we have to say to acknowledge the names of the parties. So today I'm Jane Doe, so I'll write Jane Doe. And who is Jane Doe in this case? I am the plaintiff. And since this is an application as well, I'm also the applicant. So I'll write Jane Doe, plaintiff applicant, who's also, and then I have to say who am I here. So I'll say suing as the mother and next friend to the minor. Because normally children cannot sue in their own name, so they have to sue through a guardian or a parent. So Jane Doe is saying, I'm Jane Doe, I'm not bringing this suit by myself. I'm suing it on my capacity as the mother and next friend to the minor. Then of course I put versus there. Then go back. The father, John Doe. I don't have to write that he's the father of the minor, just because I'll explain it later on here. So here he is the defendant, and since it's also an application, he is the respondent. There you go. So that's the first part of the document. Now we have to explain to the court what document it is. So the first document is a certificate of urgency. So I'll write certificate of, the title of the document, certificate of urgency. Then I power underline it. Then I come and start explaining. So normally, if it were an advocate drafting this, they would say that I, so and so, as I'm an advocate of the High Court in this matter, and explain the reason of the urgency. But Jane Doe, who is me now, I am the mother of the child, and I am claiming I'm acting on my own. I don't have a lawyer. So what I'll do is I'll just say I put in bold caps Jane Doe, being the plaintiff. Who am I in this matter? I'm the plaintiff applicant in this suit. Do hereby certify this application, because it's an application, to be of extreme urgency on the following grounds. So let me just do a bit of formatting so that it's easy to read. I will put 1.5 or even 2. Let's put it at 2 so that it's easier for everyone to read. So I have to explain why is my matter urgent, and why do I want some interim relief. So then I say 1. We start enumerating it. 1, and you have to use the word that. Okay, not necessarily, it's just good practice to do that. That the minor, who is this child, Darren Doe, has been sent out of school for school fees, school fee arrears. Then I say, just an example, that should this court not urgently intervene to compel the defendant, respondent, to pay school fee, the minor will continue to suffer from lack of or rather to suffer from interruption of his education. And then you can put as many grounds as you want. If it's also if someone has taken the child away and you want the child back, then you also explain whatever reasons that create the urgency, you put them in the grounds. And then when you're done, you have to date the document. Dated this today is the 23rd of March, so I'll date it today, 23rd March, 23rd day of March 2022. Then you have to sign it, so you center a line, put your name there, Jane Doe. But who is Jane Doe? Jane Doe is the plaintiff applicant. So let's remove the space there, and then just put it at 1 so that it doesn't take too much space. So eventually you will print it, or if you have an electronic signature, you will come and put the signature just on top of your name. Then you underline it. You underline this. So then down there, you have on the side, you have to say who prepared this document. So in this case, it's yourself. You will say drawn and filed by. You're the one who filed. Filed by Jane Doe. If you have an address where you can be reached, maybe an email address, because nowadays we are allowed to serve documents via email, so you'll say janedoe@gmail.com as an example. But you have to say where this document is going to be served. So you have to say to be served on the defendant, John Doe. And then you say, you put his email address if you know, at gmail.com. And our first document is done. That's called the certificate of urgency. So then we move to the second document. Now the main application. So this certificate is usually the first thing the magistrate will look at to see why this matter should be given priority and the application should be heard. So now we need to go and draft the main application so as not to repeat, and for the interest of time, I'm just gonna copy this and come down here and paste it as such, so I don't have to type it afresh. So all applications under the Children's Act are usually be done through a document called a chamber summons. So I'll show you how a chamber summons is drafted. So I write chamber summons. Then I power underline it like that. So once this is done, the next thing I need to put some law in it. Now you might ask, where do I get this law from? This law is the Children's Act, it's the Constitution. So I will just put a few provisions. If you have somewhere to write, you can write them down. They're usually the common provisions that are used in children matters in Kenya. So the first is the Constitution. So I'll say under Article 53 of the Constitution, it's the article that provides for the rights of a child. Then section 4 of the Children's Act, it's the one that provides for the best interest of the child. So in fact, let's add another section here, section 4 and 23 of the Children's Act, but you cannot, 23 is the one that provides for the obligations of parties, in taking care, parental obligations, yeah. And then you say, and all other enabling law as such. Yeah, sometimes we try to make it fancy by putting it underlined in italics, but for purposes of this video, we'll just leave it at that. Then we align it left. Now we start how a chamber summons. It always starts with these words, and in bold, let all parties attend. Then the rest can, the honorable, it's a magistrate in chambers, which day on the, now we don't know which day the court will give us for hearing of the application, so we leave it blank, on the dash day of dash at 9, that's when the court usually starts, 9 o'clock in the forenoon, that's before noon, or so soon thereafter, for hearing of an application by the plaintiff applicant for orders that is in capital block. Now we want to make it easy to read, so I'm going to put it in two spacing. Scroll up. So what orders? These are the prayers that we are making. So the first prayer I'm going to make as Jane Doe is, I want my matter to be certified urgent. If I don't have this prayer, my matter will not be certified urgent. So I'll say that this honorable court be pleased to certify this application as urgent and to dispense with service at the first instance. I'll explain what this prayer is. That says, don't wait for me to go and serve first before you certify the matter urgent. Just certify it urgent, read it, and give me directions, even though I have not served the other side. That's what we mean by dispensing of service at first instance. Then, prayer number 2, we say, or order number 2, we are asking, this court be pleased to direct the defendant, respondent, to pay school fees and school-related expenses for the minor. And maybe let's just jump in and order a prayer for interim custody. So here, in fact, let's edit this, because this is an application. We will say related for the minor, pending the hearing and determination of the main suit. Then you say again, this court be pleased to direct interim actual custody, care and control of the minor to the plaintiff, that's me, pending hearing of the main hearing and determination of the main suit. So that, you know, sometimes if I'm Jane Doe, I might be worried that John Doe will come and try to snatch the child away, and I want the child to be with me, so I'll ask for interim custody. Then the last prayer, you know, there might be many others depending on the circumstance. I'll just say that this court be pleased to make any other orders in the best interest of the minor, so that in case there's something I forgot and the court feels it's good for the child, it will make the orders anyway. Then I move on to the next section of the chamber summons and say to state the grounds. I would say, and which application is based on the following grounds. So remember the grounds that we listed up here, we're gonna list them down here. I'll just copy so as not to repeat it, because the grounds are usually the same, they don't really change that much. The grounds in the certificate and the grounds in the chamber summons, and then I add. So here the grounds, I'm telling the court, you know what, the minor has been sent for school fees and blah blah blah, and then I say, you know, I need to tell the court that there's an affidavit that's going to be sworn. Now every application must be accompanied by a supporting affidavit. If you do not have a supporting affidavit, the application is incompetent and will not be heard by court. So I have to tell the court that there is an affidavit later on. So I'll say, and which application is further, sorry, let me remove the bold, is further supported by the annexed affidavit of Jane Doe. Jane Doe is the plaintiff, so she will make an application and swear the affidavit, and on such other grounds as may be adduced at the hearing of the application. So I want my document to look good, even this one, so let me justify like that. See how nice it would then look. Justify it. Let me go back to the certificate of urgency and justify it as well. I think I might have already done that. There you go. So that the court feels like we are serious with what we're doing. So as usual, then we have to have this last section where we date the document. So remember this section we had here in the certificate where we said dated this Jane Doe drawn and filed to be served. So you can simply come copy it and then you go paste it down here. There. Then of course you will sign. So our chamber summons is done. So then we move on to the next document. Remember we told the court that there has to be an affidavit that we're filing. Every chamber summons must be accompanied by a supporting affidavit. So again, let's copy the front. You'll notice that this title of the document does not usually change throughout the entire suit. It will always be the same unless there's a change or there's someone new who's been added. Yeah, so we add that, then do our center align and say supporting affidavit. The title of the document is supporting affidavit. Then we do our power underline, justify left. Then we start drafting the affidavit. So I'll draft, say I, Jane Doe. Now here I can speak in first person. Remember, in the previous document here, the chamber summons, we were talking in third person, yeah? We are saying the minor has, the court should do this. It's supported by the affidavit of Jane Doe as much as it's me, but I can't say it's supported by my affidavit because it's in third person. But now when I'm drafting an affidavit, now the language changes to first person. I'm speaking as myself, yeah? So I say I, Jane Doe, of ID or postal address. Let's use ID because there might be many Jane Does. ID 1 2 3 4 5 6 7 8, and resident in Nairobi within the Republic of Kenya, being competent. You have to tell the court that you know what you're saying, and of sane mind, do hereby swear and depone as follows. This is just big language, but in short, we're just saying you're swearing to whatever we're going to swear under. So let's again make it easy to read. Justify, and then I put it to. So now I say what I want to say. Now I'll tell you guys something, yeah? Okay, this is autocorrect, which is correcting me. So I'll tell you something. The affidavit is such an important document because it is where you can bring whatever evidence you want to bring to explain to the court that you're not just making any wild accusation, but you actually have some kind of evidence to support the application. So let's start building our affidavit. So I'll say, I'm Jane Doe. I am the plaintiff applicant in this matter and thus competent to swear this affidavit. And we'll say, oh sorry, I should have started with that. All affidavits must usually say, because you're deponing that something, so I'll put that. Then I say that I am the mother to the minor and the defendant respondent is the father to the minor. So that gives context to why this application is being made and why we have the parties as this. I am the mother and the defendant is the father. What do I have to show for it? Maybe I have a birth certificate that I can be able to attach. So this is I want to attach my first piece of evidence here. So I'll put brackets after the sentence, put it in bold, see annexed. Annexed is just attaching or attached. Let me use an easier word. Attached copy of the minor's birth certificate, and we have to mark it because we might be attaching several documents and we want the court to be easy to find it easy to identify which document is which at that time. So how do we mark? So you say marked. Normal way is to use the initials. So here is Jane Doe, so I'll say JD, and it's the first document I'm marking, so JD1. So that's my first document. Now, wherever the document, that birth certificate is, when I make a copy, when I take this certificate, this affidavit to a commissioner for oaths to stamp it for me, they will also stamp that document and ensure that this is JD1 that is being referred to. so that the court can be able to look at it. So then let's move on. Thank you to autocorrect. So I say that the minor was born on, let's give a date, maybe 6th January 2016. So of course my evidence is the birth certificate, so I don't have to mark it again because I'd already previously marked it. But to make it easy, I usually like bolding the date so that the magistrate will be able to see it immediately. Then I say that on the date the minor has sent away from school, because that's what I'm saying, 20th, just a random date I'm picking, March 2022, the minor was sent away from school with a letter indicating the fee, indicating that fee should be paid before the minor resumes school. So I need to annex and attach that letter, so I'll put it in bold. See attached copy of the letter from school marked, guess it's JD2, my second bundle of document. Maybe I want to show the court that I have tried reaching the guy and the defendant and he has refused or has ignored. So I say that, sorry about that, I have tried reaching the defendant via email to no avail. Then we attach a copy of the email. See attached copy of email marked JD3. So we keep on moving like that throughout the entire matter and throughout the supporting affidavit. And once this is done, I can attach as many things as I want and say whatever I have to say, but I have to conclude with the last statement that all this is true to the best of my knowledge, belief, and conviction. Then we'll be done with that. So of course, you know, we have to date. This time the ending will be slightly different. So dated this 23rd day of March 2022. Then this is an affidavit, so it has to be sworn. So I say sworn by the said, put it in underline, and then I say Jane Doe. Normally this is the part where the commissioner, normally commissioners for oaths are the ones who are supposed to do this affidavit, but in our case, since this is the signing part, we want to do it for ourselves so that you can take it to a commissioner for oaths and you want to save money, then they sign it for you. Sworn by the said Jane Doe, then you say in the presence of commissioner for oaths. Then the commissioner will stamp and sign. Then your affidavit will be done. So this is the end of the application, yeah? So then we move on to the next document. Now we get to, so far as I've shown you, let's just put this drawn and filed by, copy it so that it's down there in the affidavit, paste. So far we've done 3 documents. The first document we've done is this certificate of urgency. Then we did this chamber summons. Now we've done the supporting affidavit. So we're moving on to, now this is the application documents. Now we are moving on to documents for the main suit, the main hearing of the matter. Yeah? So again, to save on time, I'm going to just copy the first part and I'll show you how this is going to change slightly now that we are doing the main suit document. So I will paste it. But now, since we are doing a main suit document, I will delete this part. So it's not, I'm no longer plaintiff applicant, but just the plaintiff. And here it's not defendant respondent, but now just a defendant, because now we are getting into the main meat of the matter where we will get the issues. So I want to show you how we are going to draft. The first main suit document that we do is called a plaint. So title it plaint. We do a power underline. Now plaints are numbered. The paragraphs are numbered. So the first section is defining who the plaintiff is, and you will notice here again we are speaking in third party language. Yeah, all legal documents are usually in third party, except where there is an affidavit. So let's do that. Number 1. So let's define who is Jane Doe. So I say the plaintiff is a female adult, competent and of sane mind, whose address for service, you have to say where will documents be sent in case the defendant wants to defend himself and to file a statement of defense. So say the plaintiff is a female adult, competent and of sane mind, whose address for service is care of PO Box, postal address, maybe 123456 Nairobi, and email address janedoe@gmail.com, just as an example. So normally if there were law firms representing, they would say that care of the name of the law firm and its address and where it can be found and such kind of stuff. So let's make it easy to read. So we move down. So then we continue. Let's define the defendant. The defendant is male adult. You might ask me, why do we have to specify gender? Sometimes it's very important just to clarify issues. Yeah, in Kenya, the defendant is a male adult, competent, and we assume he's also sane and of sane mind, who, and then you might not know, okay, or you might know the address of the defendant, whose address for service is maybe it's the same, or if you know the address you can say PO Box 456789 or 789 Nairobi. And then you say service, that you're the plaintiff, you will be in charge of ensuring documents are sent to him until when either a lawyer comes on board. So you say service, let's put it in bold, service shall be through the plaintiff. This is just a random example, but I'm sure you'll catch the drift as we move on. Then you start getting into the meat of the matter. So you say the plaintiff is the mother to the minor, and the defendant is the father to the minor. Then you continue explaining your story. The plaintiff, maybe you're not living together, is estranged to the defendant and has not been living with the defendant for a period of, say, 3 years. Then you say the minor was born, you have to identify the date of birth on the date that we selected. I do not remember which date that was. Let me just go up here. So we had said the minor 6th January 2016. So say the minor was born on 6th January 2016. Then you say the defendant has refused to take responsibility in providing for the needs of the minor. Then you explain everything that you needed to explain. Now here we'll not start talking about the date when the minor was sent from school, though you can mention it, especially, but just to remind the court about it. But probably by the time when you're getting to the hearing of the plaint, the court will already know and will have given some kind of interim orders for the child to be reinstated in school and fees to be paid. So you write all the paragraphs that you need to write, but then you have to do what we call particulars. So for here, we'll say particulars. So when you're wanting child support, what exactly is child support? That's what we mean by particulars. So we'll say particulars of child support. This is where you do a tabulation. So we'll say 7. The minor has the following needs. And then, so we can put it like A, food. Per month, maybe the minor spends, let's just put an approximate 20,000. Don't kill me, this is just an approximate. Shelter, how much are you spending on shelter, divided by how many people are sharing in that house. So we can just put a figure of maybe 10,000. Then clothing per month, we put say 5,000. Then medical, if the child goes to school, if the child has gone to hospital, or you can estimate, you can put it there. If not, you leave it blank, and then we'll explain it later. And education as well. So let's just leave medical and education and put them as separate paragraphs here. So I say the minor is further in need of a medical cover to ensure his provision in the event of illness. And then say the minor is attending school at the name of the school, let me guess up a name, at Sky Garden Primary School, and is in need of school fee and school related expenses as per fee structure. Then later on, maybe you also had a prayer, or you want the child to be given, sorry, let me just correct this, shelter. Maybe you want child to be given to you, you want child support, so you have to give reasons why you want the child support. So you say particulars of child support, child custody. Then you continue the numbering, so it was 8, 9, you just continue 10 there, and you say the minor is a child of tender years, because you're Jane Doe and the law says minors of tender years must be with the mother. So you say the minor is a child of tender years who needs to be with the mother. Then maybe you want to say that the father is not responsible enough to take care of the child. Then you can say that the defendant is not responsible enough to take care of the child. Then you say whatever you have to say. Then we want to conclude this document by making prayers. Yeah. So we say reasons wherefore the plaintiff, it's yourself, in third party language, the plaintiff prays for judgment against the defendant and for orders that, then you start listing the orders there. 1, legal custody. I've explained in another video the difference between legal custody and actual custody, but in a nutshell, legal custody relates to rights and responsibilities while of a child, while actual custody is talking about physical possession of the child. So most times when you're filing for child support, the court cannot grant child support without granting joint legal custody. So you'll say legal custody of the minor be shared jointly between both parties. Then you say actual custody, care and control of the minor be with the plaintiff. Then the defendant be compelled to take care of school fee and school related expenses. Then the defendant be compelled to take care of medical needs of the minor. And then whatever you want, the prayers that you want to, because you have to share custody equally. I mean, not custody, but child support equally. So what will you take as a plaintiff? So you say the plaintiff be compelled, or rather compelled, you can't say you want yourself to be compelled. You can say do take care of food and clothing needs of the minor. And then you say then the defendant do contribute Kenya shillings, just 5,000 per month to the shelter needs of the minor, so that it looks like you're sharing expenses. Then you end the document. Remember, I told you how documents are ended in a similar fashion, just the way we did it here. Dated, filed, to be served. So just copy it and go down there. Here, and then I'll paste it. So our plaint is done. So that's the first document that is done on a main suit, the first main suit document. Remember, the others we said are application documents, the certificate of urgency, the chamber summons, and the supporting affidavit. But this is the first document, main suit document. So now let's do the second one, which is an affidavit. Yeah, so every document, every plaint must be accompanied by what is called a verifying affidavit. Without the verifying affidavit, the document, the plaint is invalid. So we title it verifying affidavit. Then we do our power underline. So I say again, now it's an affidavit, so of course remember the language goes back to first person. So I, Jane Doe, of PO Box. So we can actually copy what we had written, the first part of the verifying affidavit. See this of the supporting affidavit of I did this, I do swear and upon this. So I copy just to save time when you're drafting. Let's paste here so that, yeah, because it's affidavits in the same matter will almost always start in the same kind of way. So then you go back and say, now that, remember affidavits must start with the word that. I am the plaintiff in this suit and thus competent to swear this affidavit. Then you go and say, so the purpose of a verifying affidavit is to verify that the plaintiff has read the plaint and agrees, and that, you know, that's the true position. Say, so you say that I have read the contents of the plaint and verify it to be true. Then you say that you have to say that this court has jurisdiction. So you have to say this court has jurisdiction to hear the plaint as there is no other pending suit. You can't file two suits in two different courts over the same issue. So say there are no pending suit between the defendant and I over the same course of action. Then you conclude and say that all this is true to the best of my knowledge, belief, and conviction. Then you have to date it, so you can easily just go back up the way we dated, and the last part is called the jurat of the affidavit, and you just copy it like that. So that to save on time. Then we come here and we paste it without merging the list. So there we go with our affidavit. You'll sign it, the Commissioner of Oath will sign it. So this drawn and filed by can move to the other page so that it just looks nice. So there we have our verifying affidavit, we have our plaint. So we are still drafting the main suit documents. We are not yet done, so we're going to draft a very important document called a witness statement. So we'll select this. As I said, it hardly changes. And come down here and draft a witness statement. Paste it there, center align, and we call it our document Plaintiff Witness Statement. Then let's do our power underline. So I'll tell you what a witness statement does. It tells you, it's your evidence that you will be producing in court, yeah, and enables the other side to be able to get ready to know how to cross-examine you in the event that they want to. So they need to know what kind of evidence you'll be asking so they can prepare adequately. In Kenya, trial is never by ambush. The other side must always know what is facing them so that they can be able to address. So the same way you put in a supporting affidavit and you put in your evidence, here you don't have to put in the evidence, but you just do a narration, again in first person. So let's prepare a draft witness statement here. I, Jane Doe, of P.O. Box 123456 Nairobi, do hereby state as follows. It's almost like an affidavit, but it's just a statement, so it's not a sworn statement. State as follows. Okay, let's just whatever I did, let me undo it. That do hereby state as follows. 1. There you don't have to have that. I am the plaintiff. So you're just narrating your story. In this matter, and the mother to the child, child or minor. The minor was born on the date that we put here in the plaint. You go back 6th January 2016. January, let's put it in bold, 2016. Then you continue narration. You just narrate your story and then you say the defendant has refused to take responsibility, I'm just truncating because of time, of the minor. Then blah blah blah, and then you end it there, and you can say everything, this is true to the best of my knowledge. Then you date it, you sign it, signed. Okay, let's start by dating it. Dated is 23rd day of March 2022, signed by Jane Doe. This one you do not need to do in the presence of anyone, so you just sign it and then you leave it at that. But you have to put this last part of drawn and filed by in every single document that you do. You have to put it. So we'll put it there. Let's paste it there. So there we have our witness statement. So far the documents are coming up well and they're ready to be sent, but there are two more documents which are very important, so we're going to do them just now. Copy, and then we do what is called a list of witnesses. Now, who are the witnesses you intend to call? So we put plaintiff's list of witnesses. Most times when you're drafting, you do not know all the witnesses that you will call, so you just start with the ones you know, and most of the time it's yourself, you're the plaintiff, so you say the plaintiff, and then you give yourself room to call others, any other witnesses to be called at the hearing. And then our ending, let's go and end it properly here. So let's copy, you date it and you copy it. There we go. Our list of witnesses is done. Then lastly, we go to our list of documents. This is documentary evidence that we shall need. So the last document we are preparing is a list of documents. So there we call it, let's put it in bold, plaintiff's list of documents. Power underline it, and then we'll number it. So maybe one of our evidence we shall be calling is a birth certificate, maybe school fee invoice, and then any copy of email. We had referred it earlier. Email dated, or a copy of email to the defendant dated 6th or rather 20th March. These are just random dates I'm giving. You put in the correct dates, then you say any other to be adduced, and then we end it at that. The important thing you need to know is whatever evidence you need to rely on, you must always serve the other side in advance before the hearing comes, otherwise they will object to it being produced. So there we go. So our documents are done so far, and then these are the documents that we now file in court. So we've talked about, let's just go through all the documents from beginning, just so you can know. We started with a certificate of urgency in the application stage, the certificate of urgency, the chamber summons, then we went and did the supporting affidavit, then we concluded it at that. Then for the main suit documents, you prepared the plaint, and we prepared it together. We prepared the verifying affidavit, and then we prepared the witness statement, and then prepared the list of witnesses, and finally the list of documents. So once you do all this bundle, you sign them and you prepare them, you will then file the documents in court through the e-filing portal. Nowadays in court we're filing electronically for Nairobi, and for other courts you file them physically. Now once you filed documents, because there was a certificate of urgency, you then have to keep on checking, because you will get some kind of direction from the court within 1 day or 2 days sometimes. Then you can be able to move on as such. Once you've gotten directions, you will, and it gets to the point where you need to serve these documents to the defendant, you must ensure that you use a licensed process server to do it for the service to be valid. And we will talk about service of court documents in another video. So I hope you have been informed by this. If you have any questions, please feel free to reach us out and we can be able to help you. I'm just gonna type in our email address. Our email is info@begislaw.com. My personal email is, or rather not personal but office email, is Elvis Abenga @begislaw.com. So you can reach out to me in case you have any questions, and you can see these and many other videos on our website begislaw.com. Through there's that, and our blog academy called begislaw.com/academy. So but when you get to begislaw.com, you can be able to go to Block Academy, and you will be able to see this and more videos that will be of use to you. Thank you. And just before I conclude, at BEGI'S we help people draft such documents even without representing them. You can feel free to reach us out and we will be able to help you. Have a lovely day or night or evening or morning, and we look forward to another video with you later. God bless you.